All right, the recording is going, so we're now being recorded. Thanks everybody for joining us for the second meeting of the Criminal Qualification Standards Work Group. And thank you all for participation by email and reviewing the draft that we worked on last time. I'd like to start with just a brief discussion of what we've looked at so far. I'm going to share my screen with the draft qualifications that were emailed around. Can everybody see that? Oops, where'd you guys go? There you are. All right. Can we all see the draft? Is it sharing right? Okay, good. Does anybody have any comments or questions or thoughts about the misdemeanor standards after reading them?
Just a proofreading point. In HA, it refers to 2 trials required in section G, but section G is talking about the process for obtaining an expert witness, etc. So that needs to refer to the proper subsection.
Yep. Kick off the VPN and see if it stops dropping out quality. Sorry about that. Frankie, can you say that again? I was in and out of internet.
Sure. HA refers to subsection G, but G is not talking about trials. So
Right. We need to fix that, which would be referencing back to,
I think to H.
Oh yeah. That may need to be reworded. And a highlight to that so I can look back over it. Thank you. Anybody else? General comments? The other thing I'd like to chat about is where we have highlights for numbers. So we have some discussion about what numbers of different things we're going to be requiring. But before we get to that, any other general comments? Spelling, grammar mistakes, of which there are probably some more. Okay. So let's start talking numbers. We've got this section on mentorship, which I flushed out from the discussion of our linking it to the bar mentorship program for first-year attorneys and things that they require of that. Anybody have thoughts on how many client meetings or other types of things we should require someone in a mentorship program to watch in order to be able to represent people on misdemeanors?
So I don't know that a settlement conference is necessary for something for misdemeanors. I've really only done settlement conferences for more complex felonies or Measure 11s or, murder adjacent. So, I mean, it can help with learning how to negotiate, but I don't know that it happens frequently enough. And it may happen more frequently in places I haven't practiced, but I don't see them happen frequently enough to make it a requirement.
I think at least I would probably take out settlement conferences. They seem to be a Lane, like the ones there is a Lane County specific kind of settlement conference that has to happen in every case. But I would tend to agree that in other counties, settlement conferences are different kinds of proceedings, right? Which don't always, they're less frequent. They're on more serious cases. It is a good it is a good way to see how you're presenting mitigation evidence to a court and to the DA, and how to navigate potential sentences with a client. But on an at least version for misdemeanors, I don't think that would be. I don't know if that's an at least. That I don't think that's a floor qualification for misdemeanor attorneys. Maybe for like Measure 11s at some point, but. And even then,
That
an
makes sense.
attorney might not want you to sit in on a confidential settlement conference with them, right?
That makes sense.
I want to say at least I'm gonna just start anchor setting. Like 8 client meetings would be a number that we might want to include, just because it gives at least a breadth of watching someone else work on a number of different types of cases. But I could be talked out of that in either direction as a floor for misdemeanor qualification.
I mean, I think also keep in mind that this is like only one way to get qualified. This is not the
Mhm.
exclusive way to get misdemeanor qualified. So it's not, I mean, I think B seems like probably the least likely way that someone would be qualified under these rules. So I don't really mind 8. That seems like a fair number.
Okay. Anybody else?
So I would say 10. And the only reason, I know it's only 2 more, but I just think it's one of the most important things we have to learn is how to have a productive client interview. So I think it shows that that's a prioritization from the agency and from the state to have more client interviews and client meetings as part of it. And I also agree this is probably the least likely way someone's going to become qualified, which might be
Okay.
more reason to have it be a higher number.
If we do 8 or 10, do we want more than one initial client meeting?
Well, so my question was in terms of like 8 versus 10 versus, does it matter more the number of meetings or the variety of meetings? Because like 10 initial client consults is, I mean, it'll give you a breadth of types of cases and types of clients, but discussing initial client contact stuff versus settlement options versus like, we have an offer, you're not going to like it, but this is what's on the table. They're all different things that you need to observe. So if somebody observes 10 initial client consults but never gets the settlement, the mitigation, the, who's all your names of everybody that you have who saw something, all that other stuff that generally comes a little bit later, I don't think that would be fulfilled.
I agree with that. I think maybe it should be 10 separate clients because the number is important because I think you want to have a variety of clients because every client is going to present differently. So I think it might be better to have 10 meetings with 10 separate clients, and then you could list out the types of meetings that they should be a part of, as Frankie outlined.
I don't know if the separate clients are as important as the separate types of meetings. A meeting with your investigator to explain what the issues are, and a meeting with an expert if such a thing is relevant. The, for lack of a better term, come to Jesus meeting with your client where you say, here's what we got, are we going to trial or not, and here's why it's a bad idea to go to trial. That's a really crucial meeting that I think any misdemeanor attorney really needs to see, because that's one of the hardest conversations for young lawyers or newer lawyers to have.
Mm-hmm. How would you phrase that in a qualification standard? I've been told that I appreciate the language "come to Jesus" moment. It reflects
Not appropriate for
a lot of
official
things that I
policy.
heard growing up.
Even though we
Well,
all use it.
Not
Right.
appropriate for official policy. I've also been told it's not as standard out west as it was in Atlanta where I grew up. So who knows?
Um, I,
I'm gonna try to wordsmith something in the chat just because I think better through my fingers.
Go for it.
something relating to final disposition or, you know, conclusory advice or something like
Disputes
that.
about case strategy.
Maybe that's a case strategy meeting.
I mean, that's what you're describing, right? Is a situation
Right.
where fundamentally a lawyer and a client have a dispute about what the strategy should be. The client is saying one thing, the lawyer's saying, hey, you're, on a different planet, bro.
Right. And that, that meeting of is it the kind of circumstance where I need to put this in writing because we're going to go to trial against my better judgment and I want to have a CYA letter in my file.
Mhm.
Again, no idea how to word that, but I think those are the crucial things that a mentorship in this context really should cover.
So does anybody have a real strong opinion on 8 or 10? I'm inclined.
I like 10. It's
Yeah,
a round
I-
number. I
think if you can get 8, you're going to get 10.
Yeah, I agree with that. I really don't have a problem with, I don't think it's unreasonable either way.
I think if we're talking about a minimum qualification, like a pathway to become qualified, I am not sure I want to require people see the different kinds of client meetings. I think at least a number of initial client meetings. I think if we said 10 meetings, 5 of which must be initial, that would suffice for me, because I don't know if we want to like set as a minimum qualification, like you have to see these specific interactions between a lawyer and a client, because I am not sure that we want all our lawyers to have those kinds of interactions, right? I mean, I think I'm going to leave it at that because I have to spend some time formulating this thought. But I want to see initial client interactions be a part of this. I don't know about like having strategy sessions where the lawyer disagrees with the client's decision. I'm not sure if I feel that is something that we want to necessarily be teaching, or that we want to ensure that new lawyers have that, or lawyers new to public defense have that specific experience. I don't know if we want to require that they have that experience. So I'm just, let me think about how I would express that differently. But I would limit it to 10, at least 5 of which must be initial client meetings.
Can I make sure that I'm understanding what this list is appropriately? These are or statements, right? Any one of these things can allow someone to become certified to do misdemeanors? Okay.
Reed, I don't think as it's written right now, it requires the like dispute. I think you're right. Like in saying that, we don't necessarily need that to be, a part of like, hey, welcome to public defense. And guess what? You're going to have to, disagree with all of your clients.
Yeah, I think
And
if
it's
you
kind of rare as well. I mean, at least in my experience, it's not like something that happens that much.
I think if you have like the offer meeting on there, you might wind up with one that winds up being a come to Jesus meeting, or you might wind up with somebody who's like, okay, yeah, that's reasonable, right? Like, just like any client that walks through your door.
I will say in writing it, I thought the important thing was to get people used to talking to clients. I don't know that I thought that the types of interactions beyond seeing at least a couple of initial meetings with clients to get the idea of what that was like were particularly important.
I think going over a plea agreement is also important because there's a lot of stuff that gets missed when people do those,
Mhm.
in part because people go over it too quickly, but also in part because the clients are they just go doe-eyed and glaze over.
Do you see a therapist or a counselor?
We can come back to this, but does anybody else have anything, thoughts before we move on?
Just
All right. So moving on to the felony cases. Oh, I also tacked on felony probation violations. They're together in the current standards, but we didn't specifically talk about that in the last meeting. So if anybody has issue with that, let me know. So looking at section B, as representing clients in misdemeanor cases for at least X months. And I remember last time we were talking about 12, 8, or 18 or so if they were halftime.
So my understanding of where we had the halftime versus not halftime
Hey,
discussion, it was full-time versus halftime or less. Because I think if you're just at halftime, or at halftime plus 1, that's different than being full-time, like at a public defender office, or just doing a contract full-time, then as opposed to like halftime and then half your time being family law or something. So I don't know if we want to break that into 3 is in terms of like full, half, or less.
don't worry about.
So you're saying there would be different lengths of time if you're full-time, if you're exactly halftime, or if you're less than halftime?
Or, I mean, I feel like grouping together people who are just more than full-time, just more than half-time and full-time, that's a big jump in terms of the amount of exposure that you get.
Okay. Other thoughts?
I don't know that I would agree with that. I have almost exclusively been slightly less than full-time, and our consortium doesn't allow people to be fully full-time. We max out at 0.95 just so people can represent their spouses on parking tickets if they need to. And I wouldn't say that my experience being at 0.75 FTE is significantly different than at 0.95 FTE. It's still the bulk of my practice and the same kinds of cases and the same kinds of work. There's just a little more breathing room. So I don't know that I think it's a drastic difference if it's halftime plus versus. You're right. I have also been in the circumstance of being halftime family law and halftime or less than halftime criminal law. And that is a very different circumstance. And I think that does take a little more time to get your feet under you doing the criminal work. So that part I definitely would agree with. But I think once you're doing more than half criminal work, it feels very similarly in my experience.
Anybody else? So let's, for the moment, at least leave it as is. At halftime and above is one number. Less than halftime is going to be another number. What numbers do people think?
What is it currently?
I believe it's currently 9 months.
9 months.
9 months, and there's no like half-time, full-time
Right.
on the current one. Okay.
And I don't think there's any sort of like number of cases represented or anything either. Like you could work one case for that full 9 months and that qualifies you.
Yeah.
Which is, I think we should create more parameters than that. Do we have I know we have these numbers because we talk about them in our board meetings all the time. What is like a full-time felony caseload? Do we have a number of cases? I think the ABA study, didn't they kind of
Oh,
articulate,
yeah.
here's how many cases this should be?
Oh, let me find them.
I want to say it's like 45 or something. It was small for felonies, it seemed like.
Oh,
The ABA had one number. The RAND national study is what the agency has adopted, had a
Okay.
different number. I'm trying to pull that up. And then our contracts have a third number.
Third number, of course.
I have the numbers, Jordan, if you want them.
Oh, yes, please, Carl. Thanks.
Yeah, so National RAND study, low-level felony is 59 per year, mid-level is 36, high level is 21. So we're talking about low and mid. So 59 and 36. In the contracts, it's 165 and 138. So it's 3 to 4 times what it is in the contracts. As a national workload study.
And this is the context where somebody has represented X number of clients at a misdemeanor level in order to move up to felonies.
Yes, that's what we're
Yeah.
talking about. Yep. So maybe it's
I mean, should this
closer
be
to say the misdemeanor numbers are
yeah.
what, 120 in the RAND study and 300 in contract.
It's 151 for a low-level misdemeanor, 93 for an average misdemeanor, 63 for a complex misdemeanor, and it's 300 in the contract. So if you jump to C, I
So
don't
I
know how
guess-
you go lower than 150.
Yeah, that's kind of what I'm thinking.
you would or you wouldn't? Sorry.
I think you have to at least have that be 100. I think the number has to be at
Yeah.
least 150. I think it should be higher, but it has to be at least 150 in my opinion.
I think, I'm trying to put myself in those shoes with 150 misdemeanor clients, not necessarily misdemeanor cases.
Mhm.
With 150 misdemeanor clients under my belt, I think that would be minimally adequate to start thinking about felonies, assuming that you've also had some trials and done some substantive stuff with them.
Mhm.
But I think 150 different clients would,
Well, do we want different clients or different cases? Because I guess that's a good question to ask about.
I think, different clients, because that may easily wind you up with 200 cases. And I think 150 feels kind of minimum.
I would say clients with the asterisk that if client number 1 is also client number 150, I would be okay with that person counting twice. And I don't want to get into the language about that. So I think that we should just go with clients.
I mean, the other side of that equation is one client isn't pleading on anything and has like 6 trials, right? I mean, that
Yeah.
Mhm.
that is a qualitatively different amount of work. So, when we say clients in criminal cases, the funny thing about that language is that it could be read either way. And I don't know how we feel about that. I think it should be, I think if we're doing a minimum, then the minimum would be cases, right? And then, I guess the minimum
we
would be
say
clients
whichever
because
is
they would
less?
have more. Do we want to say whichever's less or whichever's more? I guess that's the decision.
Yeah.
I think it should be
I think
clients.
from an administration standpoint, we want to pick one.
Yeah,
that we know
I
what
think
we're
it should be
reviewing.
clients because, we're client-centered attorneys, and talking about our clients as cases, I just disagree with. And so I think it's important to lead with, words matter. And so I think it should be clients.
And I think a lot of the skills that misdemeanor attorneys are building relate to client interaction and client management and, understanding all of the underlying components that our clients are using in their analysis on their case. And so I think that's the bulk of misdemeanor work is much more about casework and understanding our clientele than it really even is about trial work.
Okay.
I have
So
felt
if we're
like
talking about 150 clients, we're probably talking about misdemeanor qualification for at least a year before
Yeah.
moving up to felonies, right?
I think so.
Agreed.
Okay.
It seems
I
like an
don't-
equivalency, right?
Yeah,
Mhm.
and I don't have any hesitation. If somebody magically burns through 150 clients in 6 months, I would still like them to sit at a misdemeanor level for 6 more months because I don't feel great about that.
I don't think they're doing the work if
I
that
would have
happens.
other questions.
Yeah,
Yeah.
exactly.
Okay. Then for halftime or less, or I guess less than halftime, how many months are we thinking then?
I'd say
We're gonna have-
18 months.
18.
18 months, probably
Yeah.
at least 18.
Yeah, 18.
Okay.
And are these ands or are they
These are
ors?
ands.
These are ands. Okay.
Yep.
So on D, I saw that, that's the motions one. I don't know if you're going to go there right now, but I think that discussing how many motions, substantive pretrial motions would be good.
Okay.
Yeah.
Let's go there. What do we think as far as numbers go?
Because you say or it says a copy of the motion. So I was wondering, are we talking just one motion, or are we talking like, seems like maybe we want to do
I
one
think
of each of these.
I think as far as agency review goes, how much we want them to have to submit to us, I don't know that we want more than one motion submitted to us as an example of what they're doing. If we have questions, OECI exists, so we can always look there. But for certification, do we want them to say, I have filed and argued this many motions? I don't know that I have a number of them that I think they should have handled. Because keep in mind, we're also only asking them to have done 4 cases, 4 trials.
And Jordan, I think that one thing that we need to put is for the copy of the motion, it needs to be a motion that they were the primary author of the motion.
Yeah, they shouldn't be submitting something that their law clerk wrote.
Okay.
Or that they got from another attorney in the office and just changed the name of the client. I think that can count as motions that they've argued, but in terms of what they send us, I'd like to see a motion of that they are the primary author of.
I'll throw this out just to get started. I think that I would like to see people be able to say that they'd filed at least 5 and that they had argued at least 2. And I'm not sure that those are the numbers that I need to see, but I think that that's just someplace to start.
The only hesitation I have about stuff like this is just local county practice. I've run into this in my PCR work in Lynn County where nobody files any pretrial motions because it is the end of negotiations. as far as they're concerned. And if you are filing pretrial motions, that means you are going to trial, and those get litigated on the day of trial. And so I would hate to have that requirement be a limitation, because the practices is very low on
Maybe lawyers
on
could file the
motion
motions with a
practice.
note that says
And so-
OPDC says I have to file this motion.
Or
Wayne
I don't
was
think
the
that's
same
a
way,
large
and I don't think they
conversation.
would have cared.
Or there may be a larger conversation between OPDC, OJD, and ODAA to deal with the fact that prosecutorial processes are, preventing people from actually working their cases.
Sure. Don't get me wrong. I'm definitely PCRing based on due process violations on this kind of stuff, because it's insane to me. But the reality is that is reasonable standard practice in at
Yeah.
least one county that I know
Yeah.
of.
Well, the
so
Supreme Court has indicated that they're interested in taking up that issue, that
Sure.
offers are withdrawn when you exercise your rights. So maybe we can
Sure.
get something up to the Supreme Court and they'll stop doing it.
But in the
Well-
context of
Expect that-
preventing
Well-
people from doing felonies,
Well,
we
but
probably
I-
should make it doable today.
Go ahead,
excuse
Cam.
me. We often have people that contact us and say, hey, I've met all of these requirements, but not this one because this. And we then can look into the circumstances and either make an exception or give them something else that they need to do to qualify. So I don't know that we want to write the qualification standards based on what the ODAA's practices are. I think that if we are finding that there's a lot of people that are getting caught up in this, then that's an easier discussion for us to have with OJD after the fact than trying to get them preemptively to change their practices. So
I think it's reasonable at least to have the same number of motions as trials, because then presumably those trial cases would have some motion practice involved. And that may eliminate the issue altogether. But
What about
having more than that might become a problem.
drafted instead of filed? That
What
gets
do you
us
mean by that?
around. It gets us around the, if you file a motion, I'm going to stop negotiating with you part of it, because if you draft the motion and don't file it, you've still gone through the effort of drafting the motion. It gets you the same result as filing the motion and not litigating it, more or less.
I feel like that's kind of wasted time that nobody seems to have a lot of extra of.
I do also just feel like it's then there's not a receipt.
Don't the current standards allow, at least in like the context of a firm, someone to certify that these requirements are met, or that an attorney has like equivalent experience to this? Isn't this something that, I mean, it's kind of along to KO's point, but just like, isn't this something that's better addressed, if the problem comes up, than like by not having a bright line?
We do have an allowance for equivalent experience. And this could be a problem where we give more information on what that looks like.
I just,
I will-
Go ahead, Jordan.
Oh, I was just to say, I will say I am, as far as a minimum standard goes, I am content with setting a line at, you have argued this many motions, assuming that you will have drafted more than you will have argued.
Do we care if they're motions that were in the attorney's own cases? Because the way that we've written it, it could be, you know, you wrote a motion for somebody else's case and you argued it, and that's something that would be, to me, that's perfectly acceptable, right? Like that's meeting the requirement that I want, which is you're doing some motions practice, you're showing that you can do it.
And I like that as a solution of just, hi, I'm a freelance motion person because I got to get my motions. I got to check my motions box for my qualification. I mean, we have that already with, hey, anybody have a felony trial I can hop on because I need to get my felony qualification. And I think there's a lot of value in the freelance junior lawyers that are hopping on bigger cases with bigger lawyers, more experienced cases and practices.
5 motions is 1 in 3% of the 150 cases we're asking them to do.
Yeah.
I mean, when you think about it in terms of like that ratio, one would
I
hope.
can't think of that
also
many
about
motions that in a misdemeanor cases. Like, I don't think I did anywhere close to that.
I don't remember. It's been a while. I think
But-
now that the potential of the misdemeanor drug crimes coming back, you're going to have more opportunities for misdemeanor suppression motions.
Yeah, I mean, I if we're including Dewey's, I file a motion to suppress in every Dewey case. You know, just about. I mean, unless there's just blatantly nothing. I think it's not. I honestly think, Reed, that's a great point, which is you should be looking at the ratio to be something a little bit more aspirational towards what we would like an attorney to shoot for, as far as like how many motions they're litigating and what they're doing in their practice.
Make sure
I
they're
think
actually
that's like a
working on
really
cases.
smart way to do it.
Yeah.
Set it as a percentage of, okay, you've handled 150 clients, you know, we want 10% of those, up to a certain number at least, to go, you know, to be clients that you're doing motions on.
I
I
agree
guess
with
I
the
just-
sentiment. I don't know how you're gonna make that part of the qualification. I mean, I completely agree. I think the number of motions filed and the numbers of motion argued should be higher than 5 and 2. And
Yeah.
because the equivalency rule, this is, I think that a lot of this is aspirational, but I don't know that you can do a percentage. I think that'd be really complicated.
Yeah, we don't want people to do something on a case to meet an OPDC standard when it might interfere with what the client is doing, what the client wants, right? So I mean, that's I think that's where what balance we're trying to strike is. So I don't know if we want to link it to the trials, right? Like in, you know, if we have a certain number of trials, then in those trials, you know, even then I can't. There's a worry that we're asking them to do or asking the attorneys to do something that isn't warranted just to check this box. So it's just I understand where everyone's coming from. I agree that we need to see that people are doing this when they're moving from misdemeanors to felonies. I just don't know how to write it into a standard in a way that doesn't interfere with like the representation of the person. I can't. I mean, it's. I like I said again. I agree in principle. Like that's something that we really need to have. Really need to focus on.
And I don't necessarily think linking the motions to the trials is necessary, because either you have like you're helping another attorney and so they let you write the motion for them and argue it, or you have your trials are those clients who, you know, all the state has to do is put on the cop and play the body cam because it's all on body cam, but your client wants to go to trial because of whatever reason they want to. I've had clients tell me they just want to waste everybody's time and resources. It's a thing. So I think having each module be independent of the others is fine.
Well, and also, I want to encourage people to win their motions to suppress.
Right.
And if it's
yeah.
tied to a trial, that means you've lost your motion to suppress. It
Very
seems
good
like
point.
we'll count the motion if you've lost it, but we won't count it if you've won it. Seems to be an odd position for the agency to take. I think we need to figure out a number that will show that there is a value to the motion practice, but it isn't something where people get hung up on. And I also think that this is something where if we find people are getting hung up on, it would be possible for us to lower the numbers. But I would rather, my personal thing is I want to encourage motion practice because I think that there are a lot of attorneys that aren't engaging in motion practice as frequently as perhaps they should be.
I agree
So I
with
think I'm
Simon.
gonna-
Wondering if there's another way to say it, Jordan, or everybody, is if you said has filed multiple substantive pretrial motions with parentheses and including, I'd put motion to compel discovery in there too, as an example, but, and then end with, and argued at least 3 substantive pretrial motions. Because if you're saying multiple, and then you're prioritizing that this is something you should be doing in your practice, but we're not going to hold you to a particular number. But we also want to make certain that you've actually argued them as well. Does that make sense?
It does.
I like that. Are we
Okay.
considering
So I'm
release
gonna-
motions or bail reductions in this? No.
We talked about that at the last meeting, and I think we kind of came to the conclusion that as long as witnesses were called and evidence was taken, we'd include release motions or bail reduction. I do kind of want to move us on to our next topic. We'll talk about the Measure 11 cases. So I think what I'll do is I will send an email with those, specifically this paragraph as questions, and people can follow up that way. And I'll include the question of what motion hearings or what types of motions should qualify. So I'm going to switch over to that one. Brainstorming list that we used last time. Hopefully that switch worked. And we will start here. So we talked about splitting out felonies instead of major felonies and lesser felonies split that we have now into felonies, and then Measure 11s and sex felonies, unless somebody has a better name for that. There was a question about including gun minimum cases and a question about including mandatory minimum cases. Do we want to start with what case categories we're including, or do we want to start with what skills people need in order to handle them?
I think we need to define the thing before we can say what people need to do to get to the thing. So
I'm down for that.
Sure.
So let's take this. We know we want Measure 11s. We know we want felony sex crimes included in there.
Can I, Jordan, you've heard this
Yes.
before, but can we refer to them as 137,700 cases and not Measure 11 cases?
Yes, in the actual
as
written
it was
document, they will be
passed-
referred to as 137,700 cases.
Thank you, Jordan.
You're welcome.
This is my little soapbox. It doesn't exist. Measure 11
I have-
does not exist.
I have the same soapbox, but I am also prone to shorthand. All right.
Just to jump in, like, I don't know if I'm cutting in or jumping ahead here, but like, I have a hard time seeing why you would include the kind of like lesser mandatory minimum cases in this category. One, I think as an attorney who, like, I think maybe a little bit more recently than some of the rest of you was just recently qualified to do those cases or major felonies. Those were a good stepping stone for me as far as dealing with clients in cases where the clients are facing more time, dealing with recidivism statutes, dealing with mandatory minimums, explaining that, negotiating around that. So a lot of the felony sentencing issues are presented in those cases. I think you lose. I don't really see any. And then the other thing that makes it stick out to me even more is like when you consider the sentencing for like felony DUI or some other felony sentences that are just basically get up to that same level, and then you're not including them in this category as well. It doesn't really have a logical connection. And it allows an attorney to, like, if anything, it makes more sense to create a middle step to me than would to include these in like with 137,700 and sex crimes. That's
Are
my
you
2
thinking?
cents.
Sorry, are you thinking specifically of like 137,717 offenses, like Measure 57 offenses?
Yeah, I'm thinking like
that
repo, gun
category?
minimum,
Mhm.
you know, the stuff that Jordan kind of just mentioned, the like
Mhm.
less, you know, less severe
Yeah.
but still mandatory minimum harsh sentences, you know, that come up.
So I guess my thought would be preliminarily that we could separate out the 717 offenses because for two reasons. A lot of them will not start out as prison cases, and a lot of them will start out as prison cases and end up not being prison cases, at least depending on jurisdiction. And in a lot of counties, there's a very specific mitigation track designed for those. I would suggest that maybe we should keep gun minimum cases with 137,700 cases. And that's, at least that's been based on my experience. And the reason for that is who the clientele are. I've run into a kind of a unique category of clients on those two categories of cases, and that's folks who have relatively little criminal history, who are suddenly facing the prospect of not being releasable and going to prison for a very, very, very long time. And that requires a really different, I think, social skill set than things that I was prepared for, at least, by doing a whole lot of repo cases and doing a whole lot of misdemeanor cases. That was a real phase shift for me, was running into people who were like, but I've never been here before. I really don't understand what any of this is like. And needing somebody who could be like this became a civic priesthood for me real fast. When I first started encountering people who were like, no, but like it was an oopsie boo-boo and now 90 months. And that's true, I think, also for gun minimum cases where like horsing around turns into, yeah, but now you're looking at 5 years or 10 years, right?
I would tend to agree with that. When you're looking at repo cases, I mean, the repo for a reason, they've been through the system at least twice before. Largely, they're dealing with mental health issues, SUD, as opposed to the, guy who is drunk and waves a gun around one time and is suddenly like, wait, what do you mean I'm going away for 5 years?
That all makes sense to me. Anybody else? Things we should include or specifically exclude from this particular category?
I would also say on the other end of the spectrum with the gun cases, you can also see like the hardened gang type always has a gun on them, which is also very different than your run-of-the-mill street addict.
Mhm.
which is a lot of what you're getting with repeat property cases.
And I think also takes a more advanced skill set to.
Yes, absolutely.
Yeah.
I just want to caution that these have to be implementable. I don't know if implementable is a word, but I'm going to make it a word. In other words, the courts have to be able to know, the lawyers are going to need to know what cases they can do, and the agency is going to be able to need to know without a lot of research whether the person was qualified for those cases or not, especially if there's going to be, which I assume, something that says you don't get paid for cases that you are not qualified for, which means it's going to be, if these are not easily determined by those three categories of people, you're going to have a lot of mess and disorganization and bad feelings all around if it's not easily determined whether this is a case that falls within that category, that qualification category or not.
Which is another reason that the repeat property should be with the felony cases, because looking at the charging document, you can't tell until you dig into somebody's criminal history, as opposed to 13700 or sex felonies or gun minimum cases. Those are pled in the charging document.
Mhm.
That's a good point.
Okay. So
you could
we've got,
even set that as the name for the category. Actually, that's a pretty good way to, you could call it like enhanced sentences, you know, based, because it's like, it's all situations where Apprendi requires, you know, an enhanced, a pled enhanced sentence.
Yeah.
Just a thought.
Reed?
I think all of these are things that we will, like the attorneys will experience in the course of handling felony cases, right? And so when we're talking about 700 cases, when we're talking about like setting this like higher qualification standard, I would include mandatory minimum cases, including gun minimum cases, including Denny Smith cases, right? And I think that just that fact that there is a minimum sentence, the attorneys have to be aware, have to have a different and a different level of like experience and savvy to manage all of the things that happen on it. I know Josh points out that there are some ballot measure, or excuse me, there are some 700 cases like Rob 2, maybe Assault 2, that are like a real good on-ramp to handling these. I think one of the things that we can potentially ask for is that people second chair 700 cases with a 700 qualified attorney leading into being qualified themselves to handle it, so they can see what that first attorney meeting looks like when they have this brand new giant potential sentence, so that they know what that first attorney meeting looks like when we're going to have like a real different release conversation, so we can see what that first meeting and like all the subsequent meetings look like when they have like the stakes that are just different, right? And so the two things I think that will help us is the length of time that someone is handling, once they become qualified to handle felonies, the length of time that they're handling those felonies before they start taking these mandatory minimum cases. And then whether or not we're expecting them to work with someone on those types of cases, so that there's like a true co-counsel on that, right? And I imagine that, you know, folks at Carl's office have some type of supervision or co-counseling for the 700 cases, and I know that we do as well. Those are things that, you know, I think are possible to work out, even on a consortium of some sort. The question then is like, how does OPDC pay for it, right? So those are my thoughts. like I agree with Josh that there are like a certain type, this Venn diagram has some cases that are like really good training to on-ramp someone onto, towards J laws, towards murders, towards rape, sodomy, sex pen type cases, towards child sex cases. But I do think like that, to me, it's a hard line that
What
you
if, what
have
if
to
you
have.
took, I'm sorry.
No, yeah, no, that's a good point.
What if you took just repo out of everything else? Like left the rest of it and repo stays with the lower felonies and it's the one mandatory minimum exposure that you have there. And then, and maybe this is what you're already agreeing to, but I don't know.
Well,
That
that and
seems
Dewey's.
like a pretty useful way of breaking it down.
Yeah, I
I
don't think
like-
of repo as a separate qualification standard. I think that's just like part of the gradation of handling felonies, right? Because there's like super substantial drug cases too, like those really big commercial deliveries and things like that.
Mhm.
Those, they're going to be swimming in the felony cases, and those have prison times. You just have to get used to that. But there's the way we talk about them is we have to be client centered. We have to focus on what their needs are. But sometimes those conversations require like additional levels of preparation and experience when we get into when like being held forever or pretrial detention and things like that.
Well, and on Reed's point, I think the other thing that I typically think about is if a client is in jail and their lawyer comes in and they're talking about, the next 10 years of their life, and that lawyer tells the client, yeah, I've been doing this for like 2 years. I don't know about that.
Yeah, no, that's going to be a really hard relationship for the client to trust. That's just how that's going to be.
But at what point do we also rely on this hypothetical lawyer that's now been doing criminal cases and working with hundreds of clients for at least a year, if not a year and a half, to have that kind of client rapport and understand what is and isn't going to work for their client, and to have built this mentorship network based on all of those earlier qualification requirements to kind of go use the resources that we've forced you to build and use good judgment to interact with this client in an appropriate way. I just wonder, at what point do we rely on the knowledge that we've kind of forced them to build to actually use without our requiring it and our mandating it, and just say, we've built this common thread of common sense for you, now implement it.
Isn't that what we're doing the whole time? I mean, I think that's every step, right? Like we have built in, here's what we're going to say, you need a minimum level of common sense to do misdemeanors. Then we're going to give you some more exposure to other things that might broaden your horizons to do felonies, etc. I don't know, maybe I'm missing your point, but I think that's kind of always there.
Kind of the point I'm talking about is mandating that still at this major felony level, we're expecting co-counsel, or we're expecting, backup lawyering. At some point, I don't think that is really as helpful. Like in my experience, when I have been co-counsel on major felony cases, it has undermined the significance of my experience, because I'm just the lackey in that circumstance. And then I'm not, learning as much. The client rapport that I will have with that client will be vastly different from any client rapport that I will have with a client individually. And so I think having that individual rapport and having my mentors that I can go back to and say, hey, this happened, how do I talk to this client, or building that in ahead of time and then going in and, I'm your person, here we go. I just think that those are very different experiences and very different values from a training perspective.
Well, Melissa, you do PCR, right?
I do now, yeah.
Yeah, and so you've seen where it goes wrong. And I
I
guess
sure
so,
have.
like, yeah, that's an experience. I don't do that kind of stuff, right? So in part, we're relying on you to say, hey, I see this go wrong, and I see this go wrong for either older, like experienced attorneys on these serious cases, and I've also seen it go wrong for less like what are you might have a sense of whether or not there are like different kinds of problems that younger attorneys have on 700 cases, right? And I guess I only see them from like the trial side. I see the emergent attorneys, I guess, who are saying like, I'm having these struggles with these ideas, or like my clients are like resisting this. We try to put eyes on it every time someone takes their first 700 case, right? We try to have one of the supervisors go and be with that person for the first run up. But I guess, do you see from, I guess, this different perspective now, what is necessary or what qualifications we would want for people to have when they go in and talk to the clients?
I mean, the number one complaint that my PCR clients have is my lawyer never talked to me. I didn't understand what the plea deal was. I would say that 75% of cases is I didn't understand what I was agreeing to. My lawyer never talked to me. It comes down to a basic lack of communication and a lack of rapport. And so what I tell every once in a while, I'll give like a PCR workshop or something. What I tell people is go talk to your clients. Even if you don't have any new updates, go talk to them, build a rapport with that person, because then when it comes down to that final meeting where it's fish or cut bait, they have a base of knowledge and a base of relationship with you so that they'll trust your judgment. Whether you're a 2-year lawyer or whether you're a 20-year lawyer, that person doesn't necessarily know that. They know how you have dealt with them, how they have dealt with you, how you've answered their questions. And so if I, as a baby lawyer, walk in and am telling my client, I don't know the answer to that this minute, but I'm going to go find out and I'm going to come back to you in a week and we'll talk about it. That person has just as much, if not more, confidence in me than the lawyer that's been around for 20 years and goes, nah, that's nothing. We're not going to worry about that. And so I think that kind of focusing on the individual rapport is much more important to clients than having the co-counsel requirement or having I think a mentorship component is very, very valuable, and having a designated person that I go ask when I don't know what to do on this case. But a strict co-counsel, I don't know that is actually as valuable when those, as we talked about, those major felony, you're going away for years, mandatory minimum kind of cases, that individual lawyer and that individual client need to have a solid rapport for it to be like, I won't say a comfortable outcome, but for it'll cut down on my PCR work a lot. I'll tell you that.
I'm a big fan of having folks co-chair cases. I think it's really valuable. I have gotten a lot out of it, and I say that both as somebody who's been a first chair and as a second chair. Do you think that there would be something? Obviously, I'm in a public defender's office. We do this every week. Do you think there would be something valuable about requiring folks to staff cases, like certify that you have staffed a case with somebody else, that you have talked about this case, from front to back to the extent that is ethically possible?
For those of us not in a public defender's office, that could be very difficult.
I also I also think that co-counseling can be very valuable, and that whether it's a good co-counseling or a bad co-counseling experience in terms of actually being co-counsel or just being the lackey, I think depends on the relationship between the two attorneys who are co-counseling, because and how that's presented to the client. Because when I was first starting to try to get Measure 11 qualified, my supervisor and I did a human trafficking trial together, and he presented me as his co-counsel, and we worked together on the case at all points in time. And I, when it came to trial, I did voir dire. I I was the one that cross-examined the victims. Like, I had a really heavy hand in doing everything. And so to the client and to the jury and everybody, I was co-counsel. I wasn't like the kid tagging along with the guy with 20 years of experience trying to get qualified. And so I think it, it goes with that mentorship aspect.
So if we're looking for a way to measure mentorship or resource networks or things like that, what we really looking for is that the attorney has someone they can go to ask questions of who's been practicing longer than they have?
And that's, I come at that from our consortium has that as a built-in part of the process. So when you enter the consortium, you have a designated mentor for the first year and a half, I think. We also have a small group workshop once a week where you can staff, or once a month, excuse me, where you can staff things like that. That is kind of built in, and I have found that very valuable, but I don't know that mandating that is necessarily appropriate because people are going to find their mentors differently. I think it's a valuable thing to encourage, but the requirement of it versus find your people, build your practice the way makes sense for you and works for you. I don't know how much we can actually legislate, find the people that you want to emulate and learn how to do what they do.
I'm just gonna add that one of the things I've been looking at is like different manuals, and the Massachusetts. You all talk at the commission or at OBDC about Massachusetts all the time. They have an assigned counsel manual that's like 400 pages long, right? So we're just talking about qualification standards. They have a manual that says like these are all the things you have to do that sort of go along with the bar standards that we talked about and that are a part of that we certify, that we've read and are putting into practice. But I mean, there's a point at which I think we're going to wind up with something that is that bulky, right? Like, and I know that we're talking, there's a, mentorship. This is how things work. Go do your thing. But if the goal of the agency in this is to create a set of qualifications, then standards, then teach to the standards, and then talk about how we address people who aren't meeting those standards, then we're going to have to put more words on a page than fewer words on a page. And I think that's the goal of this. I think that's the direction of this group. And for those reasons, like I want to set high expectations, right? And if you all keep talking, like I said, Jordan, the commission or the agency keeps talking about Massachusetts, they have a training program that they make people do a certain number of, I forget how many hours of like watching videos and like going to trainings and doing things, like it's a week long or whatever it is. Like this is where I think we should be squarely pointing this ship in that direction. And I think that if there are people who are going to be taking serious cases like this, they should not be lead counsel on the first one that they get assigned. Yeah. I mean, that's just like, to me, that's a bright line, right? Like if ballot measure 11 comes through, or excuse me, if rape 1 comes through and someone has never handled a mandatory minimum case before, then on a consortium that shouldn't be assigned to them. How do we make sure that doesn't happen? And how do we get someone to the point where they are able to, or that we are comfortable about, maybe not they're able, right? Because I think all the attorneys are able. How do we get to a point where the state, you, Jordan, the state is comfortable with that person handling that case, right? And so that is why, I think these qualifications are important. And that's why I think that that's why I think that a requirement that they sit through one of those things as co-counsel is important. There is an endurance that comes from sitting through a 4-day trial, right? Or a 3-day trial that is, cannot teach, you cannot explain, you cannot describe. Like, just if you are solo for that weight, you are exhausted and broken by the end of it, regardless of how well you're doing. Like, that experience is something that is extraordinarily helpful to have someone of equal or greater qualification there sitting with you to shoulder some of that weight, right? It just gives your brain a little bit of chance to flex when you're not like in the spotlight. So all this to say, I think that these should be all of the at least the cases that we're talking about here. I'm not sure if like super substantial quantities or repeat methamphetamine or commercial drug need to be on this like higher tier. I think those can come in the regular felonies, but we should think about whether or not those are appropriate for whoever's doing the assigning. But I do think that a person needs to have these experiences before they're moving on to the higher qualification level. I think they need to have these experiences before the state is comfortable with allowing its citizens to be represented by people who have had or had not had these qualifications. I'll stop my soapboxing for now.
Weren't
So-
soapboxing, and certainly I think that the agency wants to get to that level, but the agency is not at that level. And although Jordan and I may not agree with this, our marching orders are what is attainable now, given the fact that we do have a lot of unrepresented cases in our system, and have a need for attorneys to be able to handle those cases and be able to get qualified to handle those cases. So like for the training programs, OPDC is not going to start a training program next month. And we aren't, as much as Jordan and I may want to have a training program, since it was what we were hired to do, the agency is, our marching orders are, don't go for the top of what we're doing, but get qualifications that can be done now and administered now with what we have available to us.
So, Kao, I know that you and Jordan and I see eye to eye on a lot of these specific issues, and like, because I know we've talked about this. I will just say that if those are the things that we need to have now, then bumping people up qualification levels before they're ready will lead to like not great representation, one, and then burnout and like attorneys being overwhelmed too, right? And I think that anyone who's worked at a public defender at a nonprofit where people get bumped up because there's attrition before they're ready and before we have like an appropriate like on-ramp for that, or people who are maybe in a private firm and don't have like good mentorship, or in a consortium and don't have good mentorship, that is one of the things that I think is pretty well understood to lead to people leaving the practice. So I know that you and I and Jordan and other people have talked about this. I think we all see eye to eye. I just want to say that I feel like I need to say that out loud for this.
And I think for our purposes here in these groups, what we can do is we can talk about both. We can certainly talk about where we want to end up. This is going to be a repeated process. We are not going to say, at least I hope, we are not going to say, these are the qualification standards. They will be the qualification standards for the next 30 years, like the last qualification standards were. So we'll be doing this again, maybe not this exact group, maybe not us leading it, but somebody will be doing this again. So I don't see any harm in discussing what our ideal qualifications look like. If we want training programs as part of it, we included training programs as part of the lesser felony requirements if they're available, and I don't have any problem with that, knowing that they are not available today. We do have to end this up somewhere where there is a realistic ability to implement it in the next, say, 6 months. So we do have to keep that in mind. But what I would really like to get is, what skills do we think people need before they start taking, in this case, Measure 11, 137, 700, whatever mandatory minimum, however we end up titling those cases. So
And
we've
then I
got,
take back everything I've said, and I think co-counseling is a crucial component of developing this practice. If we're not going to be able to have kind of a formal mentorship or formal training program, then co-counseling, where OPDC pays both people involved, is kind of the only viable option. KO is shaking her head at me.
KO is shaking her head at the aspect of implementing that in a realistic way.
Reed is right, and I know that Jordan agrees with me, because this is a frustration that we have. But the agency, I wanted to put it out there because I expect that what we're going to get back when we send this up, if it includes training and mentorship and co-counseling, is a big fat no. And I want this group to hear that beforehand, because then we'll be having to come back to you and say, okay, now what do we do? And
Just so
I
crazy.
also want it clear going in that Jordan and I are following what our directives have been, which is that we're talking about the next step, not the ultimate destination.
How do you teach lawyers to be qualified without teaching them to be qualified?
Well, I mean,
How do you
One day we'll have
reconcile
an
that?
answer to that question, Melissa.
the alternative to coaching is a lot more trial and error, right? If we're going to live in a world
Which
where
is terrible. Yeah.
well, sure, let's set aside the part where that like hurts the people who are
People we're
being
trying to
erred
help.
upon. But if a misdemeanor attorney doesn't get to work with a more experienced attorney to like learn how to hack it on 12-person juries, then it's going to take more than 150 clients, right? Josh.
No, I
Josh,
mean,
go
I'm
ahead.
just, it sounds like the agency doesn't really, it doesn't really want to increase the floor or make the floor higher. It sounds like that's a real problem. That anything that we do that's going to make it more difficult for attorneys to quickly transition, which is the opposite of what the standards that we're being told to implement would suggest us that we do. It seems to me, right? Like everything points in the direction of more. And how can we do that if we're going to get a no at the end of it? Because it can't be implementable.
It sounds like we are doing this so the agency can check a box, but they actually have no inclination to hear the outcome of these meetings.
I don't want to
I
give you
don't-
that impression. I wanted to just put out there because I've had that experience when we did the investigators meeting, is the investigators came up with a great program, I thought, and we then had to go and scale it back because it was something that the agency could not implement because it cost too much and would be require too much administrative work from the agency. So I'm not saying don't put this forward and don't put what the gold standard is forward. I want to make it clear on the recording that Jordan and I are telling you these were our marching orders. You guys can say we don't care. We want you all to put this forward. But if it gets put forward, I also want the group to have an understanding when Jordan and I come back and say we were told we can't implement this, that you understand why ahead of time.
And I will say I perhaps understood our marching orders differently from KO. The implementation piece is important. It is something that we should consider. But I think what we want to do is come up with standards that we can all, if not be thrilled with, live with for what people are going to need to demonstrate in order to take some level of cases. If the gold standard is what we say this is the lowest we can live with, then the gold standard is what we'll pitch. If we say, we want we want lawyers to have handled at least 120 cases to move from misdemeanors to regular felony cases, then, we'll pitch that. If it comes back and says we can only do, 80, then we may have to live with 80. But at least for right now, what I'd like to do is figure out what skills we are comfortable with someone demonstrating, how they can demonstrate those skills, and get that at least on paper before we move forward. There will be other review processes that this group is not involved in. And some of that may be taken out. We talked about that, and I think you guys all understand the old idiom of sausage making. And we may get there, we may not, but for at least the next, we've got 4 or 5 minutes left in this meeting. Let's try to see if we can get something down about what skills people need. Frankie? And
So
then Carl.
I would much rather put out what we think is what needs to be there rather than asking for what we think will get passed, because we don't know if they're gonna say that more is okay. I mean, there's 2 ways to negotiate, right? Door and face, where you ask for everything you want and then come back with something less that sounds more reasonable, or foot and door, where you ask for what you think might be reasonable, but you don't necessarily actually get where you want to go because they may just stop there. And I would, in this situation where we're talking about the future of public defense, I would personally prefer door and face so that we can get told, no, pare it down here, here, and here. And then we actually know where they're talking about, rather than going at the bare minimum and having them accepted at that point where we could have gotten better qualifications. Bringing it back to what we're looking at for this, I think part of what we should look for before qualifying somebody to handle mandatory minimum cases is to have some repo or super substantial quantity cases under their belts, where they've had those conversations and done that mitigation type work at the regular felony level. And that couldn't be qualified at the front end for repo, for example, it can be qualified at the back end, because the judgment will say sentence pursuant to 137717, and then may or may not have a departure with it.
Carl? Thanks, Frankie.
I know I have a couple minutes, so sorry. My thoughts would be to go to 700 cases in sex offenses. You would need to pretty much do the same qualifications from misdemeanors to felonies, but in the felony context. So it's also to be consistent with what we've already written for misdemeanors, with the additions of you have to co-counsel from beginning to end one of these types of cases. It doesn't have to be a trial. You just have to co-counsel from the beginning to end, at least one, before you can move up. And you have to co-counsel at least one trial of this type of case before you could move up. Because I understand that not every case goes to trials. It's not that easy, but I think you should have to at least do one. And then I think you should also have to be involved in the presentation of at least one expert witness. That's the biggest part of when you move up to Measure 11. Sorry, KO. I'm never going to be able to say that word again. To 700 cases or comparable cases or otherwise, you really not just consult with an expert, but you really need to have presented one. In my opinion, it's a big part of the trial practice and procedure. And the last one would be.
Sorry, Carl. Where would you include crossing a state's expert witness in that? Same thing, different thing, also required, not required?
I think so. I mean, I know I'm usually tend to be one that wants more baseline, but I don't know that you necessarily need to do that because if you've consulted with experts and prepared an expert to testify, and then hopefully you've had trials and cross-examined witnesses, I think it gets you pretty close to where you need to be able to cross a state's expert. I mean, ideally, I think you would have crossed a state's expert by this point. I wouldn't have any problem with it being included.
Okay.
I don't think it's
Sorry,
necessary. You might not get to
last
that
thing?
until. The last thing to consider, no, a bad idea is a bad idea, is I wonder whether it's worth putting in there something about aid and assist posture.
I think it
You know,
is.
a contested aid and assist, because you're going to have those when you get to 700 cases and higher.
I think even in felony cases, that
Mhm.
seems to be where,
That's a whole different thing.
I mean, I don't know. I see more of those in like out of custody misdemeanor cases, even. But I do think somewhere along the line that has to have been part of your repertoire by the time you're doing major felonies for sure.
And fitness to proceed has shifted so much over the last several years, both in terms of the statute itself changing, but also in terms of the population. We're getting more and more low-level misdemeanor, can't go to the hospital because of Mosman. So like aid and assist is just a whole different aspect to things. I would be really surprised if people hadn't encountered that by the time they get to felony.
But I think requiring some experience with it or some proficiency with it and verifying that is a valuable component. Maybe even from the jump to misdemeanors to felonies. Not that I want to backtrack, but I do think that that's a significant box to check.
Sorry, I'm going to scroll very fast. I know that's hard for some people to read, but I want to add that back up here. Oops, where am I?
I would be comfortable for aid and assist to have that be a certain number of CLE hours. I know some people are, I tend to be, you need to have all these, you need to do the things several times, but if
So
4 CLE hours per reporting period were a part of it, specifically on aid and assist, then I don't know if it's going to make people better at it, but it will be something that a person can attain those qualifications in the event that their caseload does not present itself with the opportunity to raise those issues.
my concern with doing it strictly on book learning is that it is so nuanced. Like I've for the last 6 or 7 years of my practice years, I've been the mental health go-to in my office, and it's not something that you can learn from a book. You have to actually like sit down and interact with the people who are responding to these internal stimuli. Making the call as to whether or not you think somebody needs to be evaluated or not, in and of itself, is a thing that needs to be learned. And you can't learn that from reading the statute or otherwise going to a CLE. You learn that from interacting with people.
I agree with that. It is, in my experience, it's completely, the more clients you meet with, the more you see particular components that trigger an aid and assist eval at least. And I think the value is in dealing with a number of clients so you can kind of see the similarities and start recognizing patterns.
Because not everybody who's aid and assist is going to be covered in bodily fluids and screaming. Like that's the easy one, right? You're going to have people who have dementia, who are low functioning but mask really well, and you're going to need to learn how to suss that out, because if you don't and you miss something, then they're gonna go see Melissa, right? Like, or it's gonna get overturned on appeal.
I think
So-
including that in the misdemeanor qualifications so that by the time they are up dealing with felonies, the odds are that that has at least come into someone's orbit. Makes sense to me.
So I do want to be cognizant of people's time. We're about 5 minutes over where we said we'd end. I'd like to keep going on discussions with this. I think what makes sense is to send out another poll for a follow-up meeting to talk about the, for lack of a better term at the moment, the 700 and sex case qualifications. I don't think we've even touched on anything that would be specific to sex cases, if there is anything. And I'd also like to talk about the extremely dangerous persons hearings as they cross over with what we're talking about in the quasi-criminal group, which I think will eventually end up setting the requirements for those. So I think there's more to chat about here, and I'll send that out along with the notes from what we've talked about in the recording from this meeting.
At the high end for checkboxes for this level, you say qualified to handle felonies for X months. I would say 24 months. They're handling felonies for 24 months. So that'd be a total of 3 years, right? 2 post felony qualification.
Mm-hmm.
I'm higher than Carl on the co-counsel. I'd say 3 to 5 instead of 1 straight through, but I don't know if that's aspirational or not. And I don't know if we want to set has tried a number of like a jury number, like a number of jury trials. I was just thinking arbitrarily that it might be worthwhile to have that in there, but I'm not wedded to that idea, and we can think about that over time. You can say
Okay.
one says Carl. Carl says 1 on beginning to end. I'll put those words in Carl's mouth.
Thanks, Rita. I appreciate that. I gotta jump,
All
but
right.
in terms of the jury trials and whatnot, I was thinking, so when I was saying you take the same standards to get to felonies and then you make it felonies. So I can't remember, I think we came into 4 misdemeanor trials to get to felonies. I would think pretty much the equivalent. You have to have 4 trials to get to majors, 4 felony trials to get to majors. If that makes sense. Consistency throughout.
That makes sense. I think I can put this in a coherent form for folks to read, and I will try to do that, but feel free to chime in over email, and I'll send that doodle poll around probably in the next day or so.
I'm gonna mail this assigned counsel manual to everybody so that they have it. It's like freaking 430 pages long. It's great. You can read it all.
Is it not
We'll
is it not
definitely read
already
it
in the
all.
Dropbox thing, Reed?
It might be. I don't know. I'll send it by
Hold on.
email anyway.
No, we did not.
I don't see it.
The standards are, but the
Yeah.
assigned counsel manual isn't. Let's fix that problem. Anyway, you can send that out to everybody. I didn't mean to discourage you from that, but I thought I put it in there.
All right. Thanks
Which I now
all.
have.
See you later.
All right,
Bye,
so thanks
Carol.
everybody.